Good afternoon, everyone. This is Avneet, and today I'm going to make a video on one of the case laws which is known as right to die, a passive euthanasia case, and it is also known as Aruna Shanbok's case, one of the famous case. So I'm going to discuss with you, my dear friends. Now, first of all, a right to die is a concept which is based on the opinion that a human being is entitled to make any decision about ending his or her life that includes undergoing voluntary euthanasia. Now, basically, the right to life is a natural right of humans which is guaranteed under Article 21 of the Indian Constitution. No person shall be deprived of his or her life or their personal liberty. Now, death can be defined, can be categorized basically of two kinds, that is, natural and unnatural deaths, which can be caused by the action as well as the inaction of a person. Now, in Aruna Shanbok's case, the NGO filed the case for a common cause when the legality of the issue was rediscussed, and on 9th March 2018, the five-judge bench of the Honorable Supreme Court gave sanction to passive euthanasia. Now, in the year 2005, a common cause registered Society for the Common Welfare of People filed a writ petition under Article 32 of the Indian Constitution to legalize passive euthanasia and to legally validate living wills. In this regard, the Supreme Court of India held that the right to die with dignity is a fundamental right and a part of our Article 21 of the Indian Constitution. Now, the bench further held that the passive euthanasia and the living wills are legally valid, and the Honorable Court issued detailed guidelines in this regard. Now, let me discuss the fact of the case with you. In 2005, a registered NGO filed a PIL, Public Interest Litigation, in the Supreme Court under Article 32 of the Indian Constitution to legalize living will and passive euthanasia. Now, prior to this, the registered society wrote letters to the Ministry of Law and Justice and Ministry of Health and Family Welfare with regard to passive euthanasia. Now, the petitioners received no response from the government and thus filed the PIL. The petitioners also contended that the right to live with dignity is a person's right till his death, and so it can be extended to include the right to have a dignified death. And that in the modern technology has given rise such a situation whereby life of the patient is unnecessarily prolonged, causing distress and agony to the patients and their relatives. Now, what was the issue in front of the Honorable Supreme Court was whether Article 21 of the Constitution, which guarantees the right of the life, which includes right to die, and whether passive euthanasia should be permitted on the living will of patients, and whether there is any difference in passive euthanasia and active euthanasia, or whether an individual has any right to refuse medical treatment, including withdrawal from life-saving devices. Now, the arguments which was in favor of the petitioners were that every individual has a right to self determination and thus should be permitted to choose their own fate. Now, in the modern medical technology that found out so many drugs and medicines that unnecessarily prolong life of causing a lot of distress and agony to the patients and his or her relatives, so it is better to die rather than being under persistent pain and suffering using medication that does not cure but prolongs the life of a patient. Now, in this case of incurable, degenerative, disabling, or debilitating, the conditions of a person should be allowed to die with dignity. As in majority of the case, the mercy petition is filed by the sufferers of the family members or such caretakers as well. Now, the burden upon the family is so huge and cuts across various domains such as financial, emotional, time, physical, mental, and social aspects. Now, right to refuse the medical treatment is well recognized in law, including medical treatment that sustains or prolongs life. The right to renounce treatment give a way for passive euthanasia. Euthanasia is terminally for ill patients provides an opportunity to advocate for organ donation. This in turn would help many patients suffering like organ failure waiting for transplantation. Passive euthanasia not only gives an individual the right to die for the terminally ill but also right to life for the organ needy patients. Now, the argument which was in favor of the respondent was the right to life under Article 21 is a natural right inherited on birth by every citizen. Okay, but euthanasia or suicide is an unnatural termination or extension of life, and thereof it is hostile and inconsistent with the concept of right to life, and thus right to life does not include right to die. Now, it is the duty of the state to protect life, and euthanasia, which would undermine the physician's duty to provide care and save life of the patients. Allowing euthanasia will discourage the search and inventions of new cures and treatments for terminally ill, and thus there won't be any prospect with regard to the discovery of possible cure for the disease in the near future. Now, euthanasia can weaken the society respect for the sanctity of life, and there is availability of alternatives such as sessions of active treatment combined that use effective pain relief. Okay, now let me discuss the judgment which was given by the Honorable Supreme Court in this case, which was held that an individual has the right to die with dignity as a part of his or her right to life and personal liberty under Article 21 of the Indian Constitution. Now, this ruling thus permits the removal of life support system for the terminally ill or those in incurable comas conditions. The court further permitted individual to decide against artificial life support and recognize the need for creating a living will. Now, the court in this particular case further laid down certain propositions regarding the procedure for execution of advance directives and provided the guidelines thereof to give effective to passive euthanasia.